Good afternoon and welcome to this session about EU citizens and the right to work. I'm absolutely thrilled that we're joined today by Dr. Dora Olivia Vicol from the Work Rights Centre, who are doing amazing work on representing the rights at work for EU citizens. As you're probably all aware, because you've turned up to learn about it today, there are lots of changes happening for how EU citizens resident in the UK can prove that they have the right to work. I'm going to start with a quick introduction about our project here at Citizens Advice Liverpool, and then I will hand over to Olivia in a few minutes. So, the EUSS project at Citizens Advice Liverpool has been grant funded by the Home Office for the last 2 years since 2019, and our grant funding will continue until September. For anyone who hasn't been aware of it yet, the deadline for making applications to the EU settlement scheme is the 30th of June this year. So in a grand total of 11 working days, all applications need to be submitted. However, once you have submitted an application, you get a certificate of application, and that proves your rights and freezes your rights, preserves your rights until that application is concluded. And employers can accept a certificate of application as proof of the right to work as long as it's not older than 6 months. People will be able to submit late applications beyond the 30th of June. So we will also continue helping people with making these late applications. We've got 3 project workers at the moment, and until September, and beyond September, we will still have a team of volunteers that are continuing. My colleague Christina has very kindly already put our contact details in the chat. That's euss@caliverpool.org.uk and 0151 522 1725. Feel free to contact us there. If you have anybody who needs to make an application, who needs help with their application, that's absolutely fine. Or if you have any further questions. We've helped quite a lot of people already. We've helped over 1,000 people submit their applications, and we've actually advised over 3,000 people who, including the 1,000, so a further 2,000 who've then submitted the applications themselves after getting some help from us. We do information sessions like this. There's a whole series of them. I'm going to share in the chat, or maybe in a follow-up email also, the flyer that we've produced for the next sessions, because we've got altogether 3 sessions with the wonderful Work Rights Centre. We've got some coming up with migrants at work. So altogether, we're doing 10 sessions right up until the end of July. And then I'm hoping to do something in September as well, and maybe take a summer break in August. I think we all need to lie down in a darkened room. Okay, as you're probably aware, the application process involves an EU passport. I've got one right here. You scan it with a mobile phone. You take a picture of the picture page. You scan the microchip. You scan the face of the applicant. You take a passport picture, not in front of a bookcase like I am here, but in front of a plain background. You answer some more questions about their residence, about how long they've been in the UK. You decide whether they're applying for pre-settled status, which is for people who've been in the UK for less than 5 years, or settled status if they've been here for 5 years or more. You enter the applicant's national insurance number. The system automatically checks with HMRC and DWP computers for official contacts, and then might find sufficient residence evidence through that. If it doesn't, or if it isn't quite enough, or if there are gaps, then it will flag it up and say, we need more evidence of your residence, for example, from March to September 2017. Then you upload a couple of bank statements for that time period and submit the application. For a lot of people, that's quite easy and straightforward, but not for everyone. Not everybody is digitally literate. Not everybody is literate. Not everybody can read and write sufficiently, and maybe certainly not in English. So there are language barriers, there are digital barriers. People who have, for example, fled domestic violence might not have any records. They might never have appeared on any bills or on any bank statements or anything like that. You know, they might have had everything in their spouse's name, and left with nothing. Or people who are homeless, the same thing. Very often they don't have any passports anymore. They don't have any identity documents. People who've been working cash in hand. It's exploited work, but exploited work is still work. So they still retain those rights that are part of being a worker. They just can't necessarily prove it. So there are lots of problems that people might encounter, and those are the sort of things that we help with. I think that roughly sums up my project. So with that, I'm going to hand over to the wonderful Olivia, who's going to tell us a lot more about the actual right to work checks for employers.
Thank you very much for listening to me today about the right to work for EU nationals and basically how to conduct it with respect for the law and for people. Okay, so in summary, we're going to look at 5 things today. We're going to look at the legal context first. Then we're going to look at the practice. I imagine that this is why most of you are here, to see how the right to work checks are conducted, via what links, what are the tripwires. Then we're going to look at some take-home points on the EUSS, then very briefly look at the new visa system and open up the discussion with questions and answers. Okay. When it comes to the legal context, the reason I'm starting with this set of scales is because I would like all of us to realize the fact that right to work checks are about striking a balance between two joint duties. On the one hand, there's duties towards immigration law, but let's not forget that as employers, we also have a duty towards employment law and equality law. And the reason I'm mentioning this is because I think there's a lot of anxiety around the EUSS and around the change. Uncertainty is a stressful psychological state to be in. And we've seen even reputable employers overreact and do even more than what the Home Office is asking them to do, and doing that at the cost of employment law and at the cost of equalities law, effectively verging on discrimination. If there's one thing I want you to remember today is that you have both of these duties and you can fulfill both with kindness and respect for everyone. So let's start with the immigration side of things. Where did right to work checks begin even? It's interesting to remember that they were not always with us, and they are a legal artifact that has a particular history. I'd like to draw your attention to the Asylum and Immigration Act in 1996. That was the first criminalization of employing a person who doesn't have permission to live in the UK. However, at the time, prosecution was minimal. Later, with the Immigration, Asylum and Nationality Act in 2006, so a whole decade later, new civil penalties were introduced for employers, and also the criminal offense for not conducting right to work check was introduced, and fines began. So suddenly, the legal framework acquired more teeth, which became even more evident another 8 years later in 2014, when the fines were increased. So at the moment, an employer who knowingly employs someone who doesn't have a right to work can risk a fine of between £5,000 and £20,000 per worker. And with this layering of law and enforcement, workplace cultures also started shifting. It's very interesting to observe that it was actually in response to employers conducting more right to work checks that evidence of the Windrush scandal emerged. Because what happened in this context is that employers started prioritizing not just the person's right to be in the country, but also the evidence. So it's almost like the document came to weigh more than the right. That was effectively the basis of the Windrush scandal. Now, the act you probably want to remember the most recent one is the Immigration Act in 2016 that makes prosecution easier. You'll all be familiar with the concept of a hostile environment that effectively delegates the bordering process from the Home Office across civil society, including employers, and that stipulates that employers can be prosecuted if they knew or had reason to believe that they were employing an undocumented worker. So this is, in a nutshell, a brief overview of the legal immigration context that we operate in. But as I mentioned earlier, let's think of our other duties as employers towards the Equalities Act and how these intersect. Some of you may know that the Equalities Act protects people against discrimination, harassment, or victimization. This includes in employment, and also, I really want us to be aware of this, it includes processes of recruitment. In fact, if I think about it, most of the questions we had about this at the Work Rights Center were from people who are discriminated against at the point of recruitment, where they did very well, they made it through the stages, and in some cases they were actually told in writing that you have the wrong nationality. That is absolutely not okay. Now, the Equality Act highlights 9 protected characteristics. So you'll know about age, disability, gender reassignment. I want to draw your attention to the fact that nationality is included in the definition of race under the Equalities Act, and this makes it a protected characteristic. Now, discrimination can take many forms, unfortunately. Sometimes it's intended, sometimes it's not intended, sometimes it's direct, and it reflects scenarios where a person is treated less favorably because of their race or nationality. So, for example, rejecting job applicants who don't have British or EU nationality. And believe me, this happens even among well-resourced employers. The second type of discrimination is the indirect one. And this basically occurs where a provision puts persons of a particular racial group or nationality group at a disadvantage. So, for example, think of scenarios where job adverts require settled status. That is indirectly discriminating because some migrants will not have been resident for that long. Perhaps some of you have seen recent reports of jobs, including in very large national employers, including in government, jobs that required EUSS now during the grace period, where technically a passport or ID is enough, they were effectively indirectly discriminating. Now, with these two duties in mind towards immigration law and employment law, what I would like you to remember as employers and HR professionals is that you need to check the right to work for anyone, including British nationals, anyone who is under contract of employment, service, or apprenticeship, and whether that is formal or informal, expressed in writing or orally. As Cosima mentioned earlier, even if you work cash in hand informally, you still have a contract, a verbal one. So whether you have workers, agency workers, employees, you have a right to or self-employed people, you have a duty to check their right to work. Now that duty is yours, the employer's. So the check has to be carried out by the employer who the contract of employment is with. You cannot really delegate it. You cannot establish what the Home Office calls a statutory excuse if the check is performed by a third party, such as a recruitment agency or your professional advisors. So it's the company whose title is on the contract that also needs to take responsibility, and that ultimately becomes liable. Liability also applies to the company rather than the individual HR professional involved. But thinking now of your duties towards the Equality Act, I'd like you to please think very, very hard about whether you discriminate or not, indirectly or not. And don't simply check the status of people who appear to be migrants because they sound different, like myself now. Otherwise, you could be breaking the law. So the simplest way to tick this is when you advertise a position, just mention that the applicant has to have a right to work in the UK. The check of that right to work could simply be viewing someone's passport. If it's a British passport, then of course they have a right to work. But you have to apply that uniformly to all of your staff. And the second thing deriving from this duty to not discriminate is to mind the consequences of discrimination. Anyone who believes that they have been discriminated against, directly or indirectly, by an employer. Oops, my presentations disappeared for a second. Well, in summary, they have a right to bring a complaint before the employment tribunal. And if the claim is upheld, the tribunal will normally order you, the employer, to pay compensation for which there is no upper limit. And you'll see references to page numbers. This is from the Home Office Guide to Employers. Okay, we've covered broadly the legal context. Let's look at the practice. Let's look first at the EUSS. We'll start with another timeline because I think perhaps it's a legacy of my professional training as an anthropologist, but I love a good timeline. Unsurprisingly, it all starts with Brexit. On the 31st of January 2020, the UK officially leaves the European Union. As some of you might remember, after 2 prime minister changes and much publicized negotiation, the UK leaves the European Union officially. What this means is that EU nationals must apply for the EU settlement scheme to secure their status in the UK. So this applies to EU nationals who are already living in the UK. Another thing is that the free movement ended as a result of Brexit. It ended 11 months later on the 31st of December 2020. This was the last date when EU migrants could arrive in the UK under EU freedom of movement rules, and it's also the last day when they could qualify for the EUSS. So they have to prove that they were resident in the UK, regardless of whether they're working or not. They have to prove presence in the country before the 31st. Or until the 31st of December. New entrants who arrive from the 1st of January need a visa to work. And as Cosima just said, in less than 2 weeks' time, the EUSS closes. Now, late applications are accepted, but the Home Office holds discretion over which of these late applications it will consider. Generally, people who are victims of abuse or labor exploitation or were in some form of care or suffered from a health problem, they should be able to still apply. But there is always that element of discretion to the Home Office. Now, with these dates in mind, I'd like to draw your attention to 2 types of right to work checks. The first one applies to today, the period from the 1st of January to the 30th of June. This is called the grace period, where EU passports or IDs are enough to check someone's right to work if they're an EU national. However, the new right to work checks that we're going to be looking at in a second apply for new workers from the 30th of June on. Now, one common myth about this is that you'll have to suddenly check the right to work of everyone on your payroll, everyone you employ or contract. That's not the case. The Home Office is very clear about the fact that retrospective checks are not necessary. So the new right to work system I'm going to be talking about now applies to new applicants. I'd like to also just spend another minute on the EUSS and address some common myths, perhaps. So one thing to remember is that the EUSS is open to EU nationals and their family members. So just because someone doesn't have a passport or ID issued by an EU member state, it doesn't mean that they don't have status under the EU settlement scheme. And I felt the need to say this because we found at the Work Rights Centre that most of the questions we get that involve a form of employment discrimination and some serious stress to the worker, they arise from people who had status as family members. So please remember, EUSS can apply to EU nationals and family members who can have a passport from anywhere in the world. The other key take-home point is that it's a digital-first process. So the check is carried out online, and I'm going to show you exactly how in a minute. If you're the employer, what you'll need is the applicant's date of birth, their share code, and I'm going to show you how that is issued, and of course, proof of ID to make sure that the person is who they say they are. To reiterate, there is no physical proof of status. This has been another bone of contention. We've had this in a case that involved one of the, I think, largest employers in the UK. The only people who hold a card that says EUSS are non-EU nationals who obtain the EUSS as family members. They'll hold a biometric residence card. No one else will. Okay, so don't Don't expect anything physical. And even with family members, they will still issue a share code and you will still use that digital process to check the right to work. And finally, as Cosima mentioned earlier, this is really important. Over 5 million applications have been made and decided on by the Home Office, but there continues to be a significant backlog. The latest statistics put it at 320,000 applications. So thousands of applications are still waiting on a decision, and it's very likely that they will continue to be waiting on a decision long after the 30th of June. So remember that just because someone doesn't have status yet, it doesn't mean that they don't have a right to work. And you can check their status through a different process, a different website called the Employer Checking Service. We're going to talk about it in a minute. Okay, now I would like us to take no more than 4 minutes to watch a couple of videos produced by myself and my colleagues that really show the process of issuing a share code from the worker's perspective, and then the process of using that share code to check the right to work. This is because it's highly abstract. This is the nature of the digital world, but it also can be broken down. It's a simple step-by-step process, and I hope that you find this useful here and that you can also come back to it and perhaps even share it with your staff later on. So here is how you issue a share code.
Because of Brexit, all EU nationals will have to prove their right to live in the UK. This is a guide to how to do it if you have settled or pre-settled status. The whole process happens online. Open a web browser and type in Prove Settled Status. Look for the official government page. You can spot it from the page address, gov.uk, and it should be one of the first results you come across. Once you're on the page, it's a step-by-step process, so pay attention. First, add the details of the ID document you used to apply for settled status. Find it and type in the serial number. Then just add your date of birth. In the next step, you'll receive an authentication code using the phone number or the email address you used to apply for settled status. Let's say this time that you get it sent to your phone. Now you've authenticated, but you still have a few more steps to take. So scroll down to the option Prove your status to someone. Select who you want to show your status to. Let's say it's your employer. Now you can preview exactly what your employer will be able to see, which is your name, picture, and right to work. But to enable them to actually see it, you need to give them a share code. Your employer will be able to use this code, together with your date of birth, to check your right to work in the UK. You can print this page and send it to them, or you can send them an automated email. Your share code is valid for a limited time period. You will have to repeat the process anytime you take up a new job or access a new service. But there's help available. Call the EU Settlement Resolution Centre if you're struggling to get into your account.
Okay, so I've been approached by another employer in the past. If you want to use this as a resource to share it with staff, please feel free to do so. It's all available on our YouTube channel. And perhaps the biggest thing to remember is that if you employ staff who were helped by someone to get their EU settled status, it's very likely that they will struggle with this process of two-factor authentication. Please don't assume that because they're a little slower or less digitally comfortable, they don't have a right to work. Please direct them to the EU Settlement Resolution Centre because that's the agency that can help them log back into their accounts, retrieve lost account details, and so on. Okay, now we've seen how to issue a share code for workers. This is how you will mobilize it as an employer.
Because of Brexit, hiring people with status under the EU settlement scheme will require a new right to work check. This is a guide on how to do it with respect for the law and for staff. As an employer, the first thing to remember is that the EU settlement scheme applies to a whole range of people. This includes EU citizens with IDs issued by an EU country, but also their family members, whose passports may be issued by a country anywhere in the world. Here's how you conduct the right to work checks. Open a web browser and look up Check Right to Work. From the government page, choose the option to check the applicant's right to work online. Then it's a simple step-by-step process. First, enter the applicant's share code. We've explained how they can generate it in a different video. Then enter their date of birth. You will see a confirmation of their name and right to work. Check that the picture matches the applicant, then file a copy of the online confirmation and store it safely. You will need it for the duration of their employment and 2 years later. It's important to remember that some people may not have received a decision on their EUSS application yet at the time that they apply for a job. This does not mean that they don't have a right to work, and you can still check it by using the employer checking service. Before you start, you'll need their date of birth, nationality, and Home Office reference number, which can be found in their certificate of application. When it comes to immigration, there's a lot at stake, but remember that as an employer, you have to abide by the laws of immigration, employment, and equality. Imposing excessive requirements that single out or penalise EU nationals who work or who want to work for you is a form of discrimination that carries serious consequences. So stay informed.
Okay, that's how you do it in practice. I'm coming close to a conclusion on the EUSS. I'd just like to reiterate some simple take-home points. The first one is that you don't need to conduct retrospective checks. And if you really feel compelled to, do it for all employees, including British nationals. Not every EUSS holder is an EU national, as we've heard, so don't be alarmed if their passport says something completely different. The right to work checks happen online and the proof is digital. So the moment that you go on the website, the Home Office has a record of the company's name, it has a record of when you made the check and who the person is. You'll need to file that. That's what you're advised to do, but at the same time, there is a digital footprint that demonstrates that you have conducted the right to work check. And also remember that you can check the right to work of an EUSS applicant, even if a decision. Now, the employer checking service is a separate service. Effectively, you have to provide details on the applicant and details on the job. Now, what the Home Office has advised when we call the employer helpline was that they will provide a kind of intermediary status within 5 days of an employer making a request. Now, I think the take-home point for that is to allow enough time in the recruitment process. If you found a really good applicant who's still waiting, give yourself and them enough time to hear from the Home Office employer checking service. They will give you an intermediary status, which means that, and the fact that you've conducted that right to work check means that even if later on the Home Office says this person has been rejected, you have still done your duty. So the employer is in no trouble at all. The only other obligation is that given that this is only an intermediary status you're getting through the employer checking service, you'll have to do another check within 6 months. And if I may, I'd also like to end this section with some recommendations just for good practice. The first would be to be patient and to support your workers if they need help in issuing a share code digitally, or if they need time to find documents from the Home Office. This is very new. People have called the EU settlement scheme an experiment in digital literacy. Please don't assume that just because they're struggling with computers, they don't have a right to work. Also be proportionate. Remember your joint duties towards immigration and equalities law. And stay informed. And if I can add another one, is to not be hostile. We have enough of that, and we have enough requirements on all of our shoulders, and kind words and just kindness and a culture of understanding and mutual support goes a really long way. I feel compelled to tell you this because of the job we have at the Work Rights Center and the fact that there is so much at stake when it comes to immigration. So much lies on people's shoulders that sometimes a very strongly worded email from a HR professional or something that sounds alarming can really drive people into states of extreme anxiety and angst and increased mistrust. And ultimately, that's in no one's interest. Here we go, the practical context for people who are on the right side of the timeline arriving from the 1st of January on. Okay, the main thing to remember about the points-based system is that it applies to everyone. This includes EU and non-EU nationals. And you might remember that politically there was this big drive from the government to harmonize the immigration system. What this also means is that migrants will need a visa first, that is before they enter the UK, but visas can be renewed or extended in the UK. Some of the visas include a frontier worker permit, which is effectively some type of visa for someone who lives abroad but holds a UK-based employment or self-employment. There can be a student visa, of course, something for intra-company transfers, so someone who works for the same company that has an outpost in Europe, say, and another in the UK, and they just come to the UK to work for that particular company. Then we have the so-called D5 temporary work visa, which is for up to 6 months of employment in agriculture generally. Then the skilled worker visas, and this is what I'll detail in a minute. It's for long-term employment in the UK. This applies to up to 5 years per visa. Now, let's take a look at the skilled worker route. This has replaced what used to be called the Tier 2 visa, and it's valid for up to 5 years. Now, there are two things to bear in mind here. Some conditions that apply to the type of job included in the visa, because it's very job specific, and then some conditions that apply to the applicant, to the visa holder. Let's start with the job. So first of all, it must be advertised by an employer who's approved by the Home Office. There is a process to becoming an accredited sponsor. The application can take up to 8 weeks, and there's also a fee depending on how large the company is and the sector. The job also has to be on the list of eligible occupations. You can check this via the table of eligible jobs, and you can check it using an ONS job code. Anyone who has an interest in sociology will be endlessly fascinated by the way in which the ONS maps our professional lives in effect. But basically every job has a code, and you'll just use the code online to see if it counts as an eligible job. I think the most significant change you want to pay attention to is also that the type of job that qualifies for a skilled worker route has to be paid at either at least £25,000 a year, £10, just over £10 an hour, or the going rate, whichever is highest. And the Home Office was very clear about the fact that under the skilled worker route, they're not really looking at applications for minimum wage jobs. We'll have to see how that pans out. There's some exceptions, but only for shortage occupations. And again, you can check what these are. These are online, or for applicants with qualifications at PhD level. Now, once employers meet these criteria on their end, there are also things that the eligible workers must do. One of them is to prove knowledge of English in most scenarios. Another one will be to obtain the certificate of sponsorship from an employer. And then to also remember to renew their visas if they want to change the employers, because the visa it doesn't allow an awful lot of professional mobility. Let's just say that it ties an applicant to a particular job. So they have the freedom to change jobs, but that also requires changing the visa. And of course, they have to update it, renew it rather, before it expires as well within 5 years. So that was a whistle-stop overview. I have to, in the spirit of full disclosure, I have to say that these are not the type of inquiries that we normally deal with at the Work Rights Center. So I'm definitely not an expert in the January on visa system. But I do hope that for those who like an intellectual challenge and long form from the Home Office, you'll find these resources useful. Please do have a look at the Guide to Employers and also the Code of Practice for Employers Avoiding Unlawful Discrimination. And don't hesitate to either call the Employer Inquiry Helpline by the Home Office or to give us a ring at the Work Rights Centre for further training.